The House will please come to order. Good morning, members. Welcome to the 29th day of the 66th Wyoming Legislature General Session, Tuesday, March 30th. Let's go ahead and call the roll.
Convening roll, 29th day, Tuesday, March 30th, 2021. Andrew. Becker. Banks. Bear. Blackburn. Brown. Burkhart. Burt. Clausen. Clifford. Connolly. Crago. Duncan. Eklund. Air. Flitner. Fortner.
Here.
Gray. Greer. Hallinan. Haroldson. Harshman. Heiner. Henderson. Hunt. Jennings. Kenner. Knapp. Larson Lloyd. Larson Dan. McGuire. Martinez. Nyman. Newsom. Nicholas. Oakley. Obermueller. O'Hearn. Olson. Ottman. Paxton. Provenza. Roscoe. Schwartz. Sherwood. Simpson. Summers. Stiff. Stivar. Sweeney. Walters. Washit. Western. Wharf. Williams. Wilson. Winter. Ian. Swanitzer. Mr. Speaker. Martinez. Larson Lloyd. Nicholas. Worf. Excused. 59 present, 1 excused.
Thank you very much. So members, if you please join Pastor Zach from Grace United Methodist Church for our morning prayer.
Again, grace and peace to each of you as you have joined us. I'm loving seeing flowers on the desk and candy over here. Pointed you out, you're gonna have to share. If you'll join me in prayer. Gracious and loving God, we come in this time to do the work of the people. May we remember that it is Holy Week, that it's the season leading into Easter, that spring has sprung, as flowers are coming up, as the sun is shining, as the wind has hopefully gone away. May we feel your presence in this place. May we continue to work together, and may we continue to hear your voice, the voice of the people, and continue to do your hard work. Lead us and guide us in grace these days. In your name we pray. Amen.
Thank you very much, Pastor. All right, members, we're going to go to work today. As you know, yesterday we had a special guest here with our U.S. Senator And then we kind of, we greeted each other to begin our week, but we got a lot of work ahead of us today. So we're going to go to work. Representative Simpson, you have a privilege of the floor you'd like to bring?
Thank you, Mr. Speaker. Before we dig in, I'd like to introduce a family that lives near me in Star Valley. Appreciate them coming to visit. Mr. and Mrs. Hoops are in the South Gallery. They are both educators, and that's their day job. In the evening, Mr. Hoops is actually my bishop of the congregation I attend to. And you may have seen him at one of your county fairs because one of his hobbies is to raise and train workhorses. And so he competes in pulling matches at the county fairs. Please welcome Kirk and Jen Hoops and their 3 children.
Well, we're so glad you're here with this Hoops family. And it seems like maybe Representative Simpson has more oversight than any other member from the farthest part of the state. He has more guests here than anybody, but we're glad you're here. Hope you enjoy your day. Journal Committee report.
Your Journal Committee reports that the Journal of March 29th, 2021 has been read and recommends that it be approved. Representatives Haroldson and Provenza.
Thank you. So members, we are going to do some enrolled acts so we can get them. Well, one, we have a backlog, just saying, and a lot of these are your bills. So some of you are wanting signing ceremonies, so hopefully you'll make those arrangements, and this helps get that a little closer for you. So we're going to do some enrolled acts. As soon as I find my script. We're at that order of business of signing of enrolled acts. First enrolled act is number 30, being House Bill 54.
House Enrolled Act 30, Original House Bill 54. An act relating to agriculture and economic development, amending the duties of the Wyoming Business Council to require support for Wyoming producers in the agriculture and meat processing industry, expanding permissible loans and grants to Wyoming meat producers and processors, limiting state rulemaking authority relating to meat processing, authorizing rulemaking, requiring a report, and providing for effective dates, being enacted by the legislature of the state of Wyoming.
I'm about to sign enrolled act number 30, being original House Bill 54. I have so signed. Next enrolled act. Next enrolled act is 31.
House Enrolled Act 31, being Original House Bill 58. An act relating to state lands, modifying the expenditure of authority of the Department of State Parks and Cultural Resources for funds in the state parks account and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign enrolled act 31, being original House Bill 58. I have so signed. Next enrolled act 32.
House Enrolled Act 32, being Original House Bill 91. An act relating to real property and conveyances, establishing procedures for removing unenforceable restrictive covenants for real property, specifying what restrictive covenants are unenforceable, providing immunity from civil liability as specified, authorizing a civil action for any new instruments recorded to remove an enforceable restrictive covenant, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign enrolled act number 32, being original House Bill 91. I have so signed. Congratulations, Representative Duncan. Next enrolled act is 33.
House Enrolled Act 33, being Original House Bill 57. An act relating to K-12 student enrollment, providing for the advanced enrollment of children of transferred or transferring military personnel and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 33, being original House Bill 57. I have so signed. Congratulations, Representative Brown. The next Enrolled Act is 34.
House Enrolled Act 34, being original House Bill 14. An act relating to rights of way, specifying requirements and procedures for rights of way along public ways, requiring an application for a blanket easement for rights of way on public roads on federal lands in Wyoming for broadband infrastructure development, providing for a working group for rights of way on public roads on federal lands, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 34, being original House Bill 14. I have so signed. Next Enrolled Act is 35.
House Enrolled Act 35, being original House Bill 21. An act relating to defense forces and affairs, extending existing preferences for entry into academic programs based on Wyoming residency to current non-resident Wyoming National Guard members, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 35, being original House Bill 21. I have so signed. Next bill, Enrolled Act 36.
House Enrolled Act 36, being original House Bill 39. An act relating to optometry, amending optometrist scope of practice, prohibiting an optometrist performing specified procedures, amending optometrists drug prescribing authority, directing the application of optometry-related fees and assessments, directing the Board of Examiners in optometry to determine continuing education requirements, amending membership on the Board of Examiners in optometry, repealing provisions that define unlawful conduct, repealing obsolete provisions relating to volunteer licensing, requiring rulemaking, and providing for effective dates, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 36, being original House Bill 39. I have so signed. Congratulations, Representative Summers. The next Enrolled Act is 37.
House Enrolled Act 37, original being original House Bill 76. An act relating to the administration of government, amending requirements for statewide payment processor services, requiring disclosure of fees, requiring a report, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 37, being original House Bill 76. I have so signed. Congratulations, Representative Brown. The next Enrolled Act is 38.
House Enrolled Act 38, being original House Bill 109. An act relating to health officers, specifying education requirements for a county, municipal, or district health officer, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 38, being original House Bill 109. I have so signed. Congratulations, Representative Hunt. Next Enrolled Act is 39.
House Enrolled Act 39, being original House Bill 148. An act relating to fees paid through the Office of the Secretary of State, increasing fees as specified, requiring rulemaking, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 39, being original House Bill 148. I have so signed. Next Enrolled Act, number 40.
House Enrolled Act 40, being original House Bill 64. An act relating to the Uniform Fraudulent Transfer Act, specifying when claims related to fraudulent transfers to qualified spendthrift trusts and irrevocable trusts are extinguished, amending time limits for extinguishing other actions involving fraudulent transfers, making conforming amendments and technical corrections, specifying applicability, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 40, being original House Bill 64. I have so signed. Congratulations, Representative Greer. Next Enrolled Act 41.
House Enrolled Act 41 being original House Bill 19. An act relating to real estate subdivisions, amending exemptions from subdivision requirements as specified and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 41 being original House Bill 79. I have so signed. Congratulations, Representative Duncan. Next Enrolled Act 42.
House Enrolled Act 42 being original House Bill 104. An act relating to trusts, amending default and mandatory rules for trusts, providing for the enforcement of foreign judgments as specified, making conforming amendments, amending provisions related to the duty of loyalty of trustees, specifying applicability of the act to existing trust relationships and the principal places of administration, amending requirements for directed trusts and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 42 being original House Bill 104. I have so signed. Congratulations, Chairman Greer. Next Enrolled Act 43.
House Enrolled Act 43 being original House Bill 107. An act relating to the state retirement system, authorizing retirement system disbursement mechanisms approved by the state auditor and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 43 being original House Bill 107. I have so signed. Congratulations, Representative Henderson. Next Enrolled Act is 44.
House Enrolled Act 44 being original House Bill 217. An act relating to public health and safety, modifying the Department of Health grant program for community health centers and rural health clinics as specified, repealing a sunset date and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 44 being original House Bill 217. I have so signed. Congratulations, Chairman Wilson. The next Enrolled Act is 46.
House Enrolled Act 46 being original House Bill 122. An act relating to game and fish, increasing conservation stamp fees, establishing a new account within the Game and Fish Fund, depositing fee increases as specified, authorizing expenditure of fee as specified, imposing Game and Fish Commission reporting requirements on specified account expenditures, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 46 being original House Bill 122. I have so signed. Congratulations, Representative Western. Next Enrolled Act. Next Enrolled Act is 47.
House Enrolled Act 47 being original House Bill 52. An act relating to school nutrition, codifying a project that provides grants for school districts to increase the availability of Wyoming meat products and school nutrition programs, requiring matching funds, authorizing the Department of Education to accept donations and other outside funds as specified, requiring rulemaking, providing an appropriation, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 47 being original House Bill 52. I have so signed. So members, now we're going to Senate files. Senate files. The next Enrolled Act is number 15.
Senate Enrolled Act 15 being original Senate File 35. An act relating to administration of government, approving the implementation plan to transfer the budget division of the Department of Administration and Information to the State Budget Department, specifying duties of the department, conforming provisions to reflect responsibilities, recreating, renumbering, and amending statutes for the Department of Administration and Information, repealing conflicting provisions, directing the Legislative Service Office to correct statutory references, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Senate Enrolled Act 15 being original Senate File 35. I have so signed. Next Senate Enrolled Act is 16.
Senate Enrolled Act 16 being original Senate File 21. An act relating to administrative procedure, amending the permissible district courts where judicial review for the agency actions may be sought, specifying applicability and providing for the effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Senate Enrolled Act 16 being original Senate File 21. I have so signed. Next Enrolled Act, Senate 17.
Senate Enrolled Act 17 being original Senate File 23. An act relating to public meetings, authorizing an executive session for safety and security planning, making conforming amendments and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Senate Enrolled Act 17 being original Senate File 23. I have so signed. Next Enrolled Act 18.
Senate Enrolled Act 18 being original Senate File 119. An act relating to the Western Interstate Commission for Higher Education, WICHE repayment program, including veterinarian medicine students under WICHE repayment program requirements, providing applicability and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Senate Enrolled Act 18 being original Senate File 119. I have so signed. Next Enrolled Act 19.
Senate Enrolled Act 19 being original Senate File 93. An act relating to public funds, adopting a risk profile standard for the investment of funds of the state which may be invested in equities, including stocks, repealing specified maximum amounts of state permanent funds which may be invested in equities, including stocks, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act number 19, Senate File 93. I have so signed. Next Enrolled Act, Senate 20.
Senate Enrolled Act 20 being original Senate File 79. An act relating to school finance, authorizing school districts to bill for school-based services for Medicaid eligible students as specified, providing reimbursement to school districts for administrative costs, providing appropriations, authorizing a position, requiring reports, and providing for an effective dates, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 20 being original Senate File 79. I have so signed. Next Enrolled Act 21, Senate.
Senate Enrolled Act 21 being original Senate File 72. An act relating to administration of government, removing a preliminary financial reporting requirement of the state auditor, repealing the Financial Advisory Council, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 21 being original Senate File 72. I have so signed. Next Enrolled Act 22, Senate.
Senate Enrolled Act 22 being original Senate File 62. An act relating to the Office of Consumer Advocate, repealing the existing sunset date and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 22, Senate, being original Senate File 62. I have so signed. Next Enrolled Act 23, Senate.
Senate Enrolled Act 23 being original Senate File 40. An act relating to trade and commerce, amending definitions applicable to the Wyoming Money Transmitters Act, amending actions and entities exempted from the act, amending fees, bonds, and security requirements, clarifying application procedures, repealing definitions of the act, specifying applicability, and providing for the effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 23 being original Senate File 40. I have so signed. Next Enrolled Act 24.
Senate Enrolled Act 24 being original Senate File 39. An act relating to trade and commerce, defining personal and organizational digital identity, establishing requirements for the attribution of acts taken through a digital identity, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 24 being original Senate File 39. I have so signed. So thank you, reading clerk. Members, one of the reasons we try not to let them pile up too much is that the reading clerk doesn't have to read off all those bill titles for, I think that was about 18 minutes of bill titles he just read for us. So thank you, reading clerk. And immediately we'll go into standing committee reports. So while he's in practice, we might as well keep him going. Standing committee reports.
Mr. Speaker, your committee number 4, Education, to whom was referred Senate File 130 engrossed, Charter Schools, respectful report, same back to the House with a recommendation that it do pass with the following amendments. Ayes, Representatives Andrew, Brown, Nyman, Paxton, Summers. Noes, Representatives Connolly, Harshman, Newsom, Obermueller. Representative Paxton, Chairman. Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom was referred Senate File 152 engrossed, Connection of Utility Services. Respectful report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Blackburn, Clausen, Clifford, Duncan, Air, Hunt, McGuire, Roscoe, Swanitzer. Representative Swanitzer, Chairman.
All right, so members, we're going to be going into second reading, then third reading, consent, regular, and then we'll have our request to concur, as you are aware of, and then adoption conference committees. And then depending on how the day goes, hopefully general file today. Speaker Pro Tem Greer is going to be taking over much of this day, as I have other obligations I need to attend to. I certainly be available if somebody needs to visit about something, but for the floor work today, the Speaker Pro Tem will be taking those duties. Speaker Pro Tem Greer.
Will be just a moment while the chief clerk organizes some amendments. Yep, thank you. All right. Members, we're at that order of business. Bills on second reading. First bill for our consideration is Senate File 19. There are amendments. Representative Stith.
Mr. Chairman, I move second reading amendment number 1 to
May Representative Stith. I'm used to committee work where I go right into it, but the reading clerk will read the bill. Sorry, Senate File 19.
Senate File 19, sponsored by Judiciary, Public Health Emergencies, Immunity Amendments, an act relating to public health and safety.
Okay, there is an amendment. Go ahead, Representative Stith. Thank you.
Mr. Chairman, I move second reading amendment number 1 to Senate File 19 and ask for your favorable consideration. What does this amendment do? On page 7, about 2/3 the way down the page, there's a requirement in the current bill draft that any claim alleged for COVID-19 liability be stated with particularity, and that it be proven by clear and convincing evidence. What does the amendment do? The amendment deletes the requirement that the plaintiff state the cause of action with particularity. and prove the case by clear and convincing evidence. So what's the reason for this amendment? You're already familiar with this. Normally in a case, when you go to civil court, you go to case, you have to prove your case by a preponderance of the evidence. That means that you have to prove that your version of the facts is more likely than not, right? Whereas clear and convincing evidence means that you've proven that the facts in your favor are highly probable. All right, so the Wyoming Supreme Court has issued 580 opinions where it talked about clear and convincing evidence, 580. I have not looked at all 580 of them, but I have looked at 100 of them. And the 100 most recent ones involve 4 different categories. Termination of parental rights is far and away the largest category where this gets brought up, right? The next largest category is when you are trying to revoke a professional's license or discipline someone, like discipline a judge. The next category is when you are infringing upon someone's constitutional rights. So for example, if you have a free speech right, but the plaintiff says, hey, you defamed me, right? And used with actual malice, then that has to be proven with clear and convincing evidence because you have a constitutional right at issue. So termination of parental rights, revoking someone's right to make a living doing their profession, and constitutional rights. Those are the instances. The other one is fraud, right? Fraud is a tort. Fraud has to be proven by clear and convincing evidence. Fraud carries with it a special penalty, however, because with fraud, you get punitive damages, right? And punitive damages are not just compensating you for your loss, but punishing you for bad conduct. So those are the sort of the 4 categories: termination of parental rights, taking away your professional's license, infringement of constitutional right, or fraud. That's when we have used clear and convincing evidence as the standard. So there's a children's show that we all saw as kids with puppets, and there was a song that went along with it that went something like, which one is not like the other, okay? And so this is all about which one is not like the other. And so what I'm asking you to think about is a tort claim based upon the fact that you stayed in a hotel or went to a dude ranch or went to a restaurant and got sick, and you think you got COVID-19 as a result of your stay at the hotel, for example. Is that like terminating someone's parental rights? Is that like revoking your license to practice your profession? Is that like infringing your constitutional right? And I would say, no, I don't think it is. I don't think we need this heightened burden of proof. Think, for example, if you're at a restaurant and 2 things happen. As you're leaving the restaurant, you trip and fall on a rug that's rolled up, you fall down, and then the cook comes out to try to help you, and the cook has really bad breath, right? Really bad breath, right? Okay. And so you get taken to the hospital, right, for your hip that you've knocked out by stumbling. But while you're there, you were also diagnosed with COVID-19. And it turns out the cook had COVID-19, and you know that you were exposed, right? Okay. So in your trial, when you're suing the restaurant for both your hip that's been out of joint, that you have to prove just by more likely than not that it was their fault, that that rug was flipped up. But when you're proving the COVID-19 liability claim, you'd have to prove by clear and convincing evidence that it's highly probable. And it's just strange because we should treat similar things similarly in the law, okay? So that's why I think we should take out the clear and convincing evidence. There's really no need for it. We have not, to my knowledge, had a single case filed in the state of Wyoming alleging COVID-19 liability. I don't think the sky is going to fall if we have the regular rules. The danger with this provision as written, in my view, is not so much that the sky is going to fall if we keep it in, but rather that if we start carving out clear and convincing evidence for this kind of tort, then suddenly it'll be for slips and falls and for everything else. I mean, what's the principled reason to not make everything, make clear and convincing evidence the burden of proof for everything? So that's one half of the amendment. The other half of the amendment is this stated with particularity. Perhaps not a big deal, but it does happen that you get injured and you don't know exactly what the facts are, right? You don't know exactly what happened. And in the court system, the plaintiff's lawyers use the discovery process to find out, right? I typically am on the defense side, just to let you know. I'm typically on the side of the insurance company. I'm typically blaming the victim for their injuries. It's what I do. Okay. You know, right? Okay. But I think this provision, this stating with particularity and the clear and convincing evidence just goes a step too far. I just think it's a giveaway to the insurance companies. I don't think it's really related to business people's confidence to open their doors. Last May, during our special session, we were really concerned that businesses would not open, that they would stay closed because they were so worried about COVID-19, right? And so we took care of it last May. We passed an immunity statute that said if you act in good faith and compliance with the state health officer's orders, you get immunity. If you comply with your local public health officer's public health orders in good faith, you get immunity. That's already the law. So sorry for the long-winded presentation, but on and for the amendment.
Okay, we're on our first time members. We'll go with Mr. Majority Floor Leader Summers.
Mr. Speaker Pro Tem, thank you. So I have a question kind of back on your restaurant example. So what if the cook had cholera and he had transmitted cholera to every guest in the restaurant? What standard would that be viewed at under current law?
We're on second reading rules. So Chair of Mr. Chairman.
Yeah, thank you, Mr. Speaker Pro Tem. So on and against this amendment and for the bill, and I think it's it's a valid conversation for us to have. Same conversation we had in the Judiciary Committee. We looked at both. I mean, the reason why we had that conversation is because what you're literally discussing is the bill right now. So if you don't think that this bill should move forward, then you should vote for this amendment because it literally will gut the bill. The bill, because remember, during my presentation, and you could look now at the bill on page 6, we already have immunity from liability in our statute for public health emergencies for healthcare providers and other persons, including business entities. That already exists. So that's already the law. So what this bill does is exactly what the amendment attempts to undo. It turns the dial on the floodgates by imposing 2 changes, and that's the particularity, state with particularity, and the burden of proof. And the idea behind that is not to prohibit a good lawsuit from going forward, and I don't think it would, because remember, this doesn't restrict gross negligence. If the act was so negligent and so obvious, so willful, so wanton misconduct, that's going forward no matter what. All this is doing, when we talk about state with particularity, what we're doing is adjusting something called notice pleading. So notice pleading is when a lawyer gets to say, somebody stayed at a hotel, they got COVID, they believe they got COVID, they believe they got it from the hotel, here's my lawsuit. Just enough to get in the door. And then as the presenter of the amendment pointed out, then they go through a discovery process to determine whether there's any facts to support that. All we're doing right now is twisting that dial just a little bit to say, you know what, we want you to state with some particularity, something more than I stayed at a hotel, I believe I got COVID from that hotel and the hotel's responsible. Something a little more. And the idea is it's not really, the hotel is probably the bad example because the idea of the bill is not to protect the global hotel chain. It's the mom and pop shop that I guarantee cannot pay these attorney's fees. And the other conversation we haven't had is insurance. That's a huge issue right now because there is a gap in insurance for businesses on COVID-19 liability. So they don't have insurance unless they fall within a small category of reinsurance, which we know very little about, and there's very little access to that. So the businesses that came and testified before the Judiciary Committee, they want this bill, and they told us they don't have insurance. So now think about that. Global hotel, okay, maybe they have something in the bank to pay for attorney's fees. But a local mom and pop shop with a lawsuit that just says, I think I got COVID and I think I got it when I came into your business because I think I saw someone not wearing their mask. defending that lawsuit through the discovery process, when you have to go through that process, that's where the money is spent, is in discovery. And that's what we're trying to prevent. We're just saying we're not preventing lawsuits from being filed if they are legitimate. We're just saying you need to state a little bit more. And is this a little bit different? Yeah. Is clear and convincing the right standard for this? I don't know. But is COVID-19 something that this body or this nation has dealt with before? Absolutely not. It's a pandemic like nothing anyone in, I think, this room has ever seen. So are we dealing with it in a little bit different way? Our laws weren't designed to contemplate that floodgate of lawsuits. So we're stepping out, and we asked, don't get me wrong, we asked how many lawsuits have been filed, and I'll tell you 0. But that's not, we're not being retroactive here. We're being proactive. We're getting ahead of it. And this, we're still in the midst of the pandemic. The health orders went into effect about 1 year ago. And I'm an attorney, and most of the people that walk into my office don't walk in with a problem the day after that, something occurred. The discovery of an injury usually takes months and sometimes years, especially when it's medical related. It takes a long time to discover that injury. So, and I'm not saying that there's going to be a lot of lawsuits, but what I am saying is that even one lawsuit that simply says, I think I got COVID, I think I got it from your hotel, I think I saw someone not wearing a mask, could be the end of the mom and pop shop in your locality. So I think that these dials are appropriately turned to limit lawsuits. And so I'd ask you to vote against the amendment. With the amendment, the bill does nothing. We're defaulting back to our existing statute. So we really don't move the ball forward on protecting our businesses.
Representative Washut.
Thank you, Mr. Chairman. So the game is, how are these different? How are they the same? All right. And you've all played that game. You look at the picture, and sometimes you have to look really close to see how they're the same. And I'd suggest that losing one's professional license means the loss of your livelihood, the loss of your ability to use your skills in that area for your livelihood. And the same risk applies to our mom and pop businesses, our guest ranches, and those folks who do not have insurance coverage to protect them from liability during a pandemic. And so the clear and convincing standard is appropriate when the livelihood of those guest ranches, restaurants, small mom and pop businesses is on the line. And so I just ask you to recognize that similarity, that if you lose your guest ranch, if you lose your restaurant, if you lose your small business, you've lost your livelihood every bit as much as if a doctor or a lawyer has his license revoked. So clear and convincing evidence is the appropriate standard in this circumstance. And if you care about your small businesses and keeping them open during this troublesome time, vote no on the amendment and for the bill.
Representative Duncan, for your first time.
Thank you, Mr. Speaker Pro Tem. So I don't know about all you guys, but when the two attorneys get up and they battle of words against each other, it all mushes in my brain. So to put it simply, if you vote for the amendment, you kill the bill because the amendment guts the bill. So against the amendment, on for the bill.
Representative McGuire.
Thank you, Mr. Chairman. Just adding my voice in opposition to the amendment. So the issue is, as it was set up before, there are really 3 different layers of proof. And there's by a preponderance of the evidence, which is 5149, clear and convincing evidence, which is the next layer up. And the reason that I feel that that is appropriate is because put yourself in the shoes of the business owner, and you're going along, and 6 months later, you get that dreaded letter that says you're being sued. Well, how in the world do you defend against that? And the example of the cook with bad breath, we don't know who has COVID. We don't know who the asymptomatic carriers are. We don't know if an individual who walked into the restaurant passed by an individual who had COVID on the way through the parking lot. There's just absolutely no way to defend against that. So what that means is that these claims will go on to the insurance carriers and they'll be settled as nuisance claims. And that ultimately, it goes against your insurance. I mean, you can say, okay, well, I wasn't at fault, but I guarantee you that if your insurance carrier pays out, later on, you will pay that insurance carrier. It's just like automobile insurance. You say, I got a broken windshield, and they repair your windshield. Well, guess what? Pretty soon you're paying for that windshield one way or the other. So I think that it's appropriate to have a slightly higher, this is not a burden that you can't overcome. It's a slightly higher burden. And I think that in these days, and especially with something like COVID-19, where you just don't know where you got it. If somebody goes home tonight from this chamber and gets sick with COVID-19, who did you get it from? Yeah, I see some people pointing fingers, but we don't know. We don't know who the asymptomatic carriers are. We don't know who's really sick. We just don't know. So I think it's an appropriate burden, and I would be against the amendment. Thank you very much.
Representative Williams.
Thank you, Mr. Chairman. On and against the amendment and for the bill, I agree wholeheartedly with the good chairman from Judiciary that this amendment indeed guts the bill. What's important to the bill? As a small business owner, I'm well aware that the statute of limitations is going to be in effect for a few years. And it's time for us to help small businesses stay in business, avoid frivolous lawsuits and settlement seeking actions that drain small businesses. They've suffered enough through the past year, and I am against the amendment and for the bill. Thank you.
Okay, any other members wish to speak against the amendment for their first time? Go ahead, Representative Harrelson.
Thank you, Mr. Chairman. So just, I want to clarify something that I think is important here. This is not taking someone's ability away to file a lawsuit. That's a freedom that we have in this country. What this does is this, if someone is trying their best and something doesn't go right, that's one thing. If it was a deal where I were an employer and I were to say, you know what, you're sick, well, you're coming to work or you lose your job. Well, I just brought it to a whole nother level. At that point, there should be something that moves forward in that case in a negative light, because I willfully made someone who was sick come to a place of employment. Other people got sick because of that. Obviously, that's a lawsuit that can move forward. But in a situation where someone's trying their best to get their business open back up and it doesn't go right, this is going to protect them from that. And so we need to protect these small businesses. The businesses in my community are saying, guys, we need this protection because we're already on the ragged edge and we don't want to see a lawsuit kick us over. So definitely against the amendment for the bill.
Any other members for their first time? Any members for the first time? Any members for their second time? Second time before the sponsor. Representative Stith.
Mr. Chairman, thank you very much. To respond to the question from the representative from District 20 about the example of where the restaurant worker has cholera, he's exactly right that under our current law, the victim would have to prove exposure by preponderance of the evidence. You'd have to prove that it was only more likely than not. If you get cholera at the restaurant, you do not have to show that it was highly probable, just that it was more likely than not. So think of this bill as the thank goodness I got cholera at the restaurant bill, okay? So with respect to the question about if the employer says, I know you're sick, but you're coming to work anyway, and how that's willful, right? I think it's a really good, interesting point, right? And that's where the states with particularity comes in. Because when you're in the hospital and you've got COVID and you're near death, say, and you know that the restaurant employee also had COVID because maybe they or in the hospital bed next to you. And that's how you know that that person had COVID-19. What you're not going to know is that the employer called up that employee the day before and said, you better come to work even though you're deathly ill. You're not going to know that. And yet this bill would require you to know that in advance. That's why we have discovery. So it's a particularly bad combination. The states with particularity and the clear and convincing really does certainly chills litigation, right? Definitely going to chill litigation. But I think we have to be fair to everybody in society. So thank you very much, on and for.
Members, we are voting on second reading amendment number 1 to House Bill 19. All those in favor say aye. Those opposed? The amendment has not been adopted. Senate File 19 having been read 2 separate times, the question is, shall the bill be read a third? Hearing no objection, is so ordered. The next bill for our consideration is Senate File 83. The reading clerk will read the bill.
Senate File 83, sponsored by Senator Wassenberger. Gillette College Community College District, an act relating to community college districts.
Senate File 83 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, is so ordered. The next bill for our consideration is Senate File 89. The reading clerk will read the bill.
Senate File 89, sponsored by Senator Cost, Public Utility Safety Lights, an act relating to motor vehicles.
Senate File 89 having been read 2 separate times, the question is, shall it be read a third time? Hearing no objection, it is so ordered. The next file for our consideration is Senate File 102. Reading clerk will read the bill.
Senate File 102, sponsored by Senator Driscoll, unclaimed cooperative utility deposits and payments, an act relating to cooperative utilities.
There are amendments. Chairman Nicholas.
Thank you, Mr. Chairman. Ladies and gentlemen, I bring you and ask for your favorable consideration in second reading amendment number 1 to Senate File 102 and ask for your aye vote.
Could Chairman Nicholas just formally move the amendment, please?
I did, but I would
No,
move.
you,
Senate
Chairman
File-
Nicholas, you said you bring us, and I think we need to have it moved. Thank you.
I bring and move this second reading amendment number 1 to Senate File 102. So ladies and gentlemen, you may recall, this is the bill where the cooperative would like to, after 2 years, keep the funds on deposit when the folks who own the deposit where you can't find them. And this is a simple amendment. Basically, what it provides is that after 2 years, the cooperative then takes the funds, submits them to the unclaimed property at the state treasurer's office for 3 years. And then if there are no claims on the property at the end of that 3-year period, so a total of 5 years, the state treasurer also remit the funds back to the cooperative. So this is just an attempt, folks, to give, number one, sufficient time for those folks who have maybe moved 2 or 3 times and they're hard to find. The state treasurer, they has a website and all the names of everything pops up on that website so that once they get them, they'll be able to have more access. And they also publish this information. And so so what I didn't want to do is make it too burdensome for the cooperative to have to reach out and try to chase people down. So that will now be the function of the state treasurer's office. But then after the 2 years plus the 3 years, then the funds can still remit back to the state treasurer. So please support the amendment.
Any members for the first time? First time, Representative Ayer.
Thank you, Mr. Chairman. I don't believe this amendment irreparably damages the bill. However, I just have a question. Does it create a larger burden for the state unclaimed property division in keeping track of those funds separately so that they can then remit them back to the cooperative after the 3-year period?
Any other members for the first time? Any members for the first time? Representative Flitner.
Thank you.
Chairwoman Flitner, excuse me.
Thank you, Mr. Speaker Pro Tem. Just, I think if the essence is to hang on to that a little bit longer, I think it would make more sense just to keep it in the hands of the cooperative as opposed to the back and forth with the state treasurer's office. So that would be my thoughts. So on and against.
Any other members for the first time? Members for the first time? Moving on. Any members for the second time? Second time before the sponsor? Sponsor? Okay, to the sponsor, Chairman Nicholas.
So a couple things. It's interesting. I'm a member of two co-ops, and I've gone 2 or 3 years on occasion where I've moved and moved around, and eventually caught up with them and keep receiving payments. And so, but what my experience is they do not do any type of extensive search to try to find these folks because they're not required to. They file the regulations which say last known address. If this doesn't pass, then what they really should do is, and perhaps like the next amendment, is they need to make a bona fide search to find these folks. You can go online right now and find almost anyone in the United States if you pay a certain fee to do it. And if there's enough money involved, then there should be that responsibility. Another thing that this does, though, by the way, is if you take it and send it to the unclaimed properties, essentially it's providing a layer of immunity to the co-ops and their obligation to find and locate the individuals. So I would think that this would, from a 10,000 foot level, that the co-ops would say this is a pretty good deal for us because we'll be immune for it because the property is transferred to the state of Wyoming and then back. You may recall that I brought a bill in order to have all the funds that were in the unclaimed properties. Eventually, it's cheap to the state. And I had a hard time on this floor saying 25 years. That if it sat there 25 years and it was less than $1,000, then it ought to go back, it ought to go to the state. And this body turned me down on that particular bill. And now we're saying 2 years without knowing what the notice requirements are, they get to keep the funds. And so that's to me, that just doesn't feel right, doesn't sound right. So I think this helps fix the problem.
We are voting on second reading amendment number 1 to House Bill 102. All those in favor say aye. Aye. Opposed? No. Amendment's adopted. We're now on to second reading amendment number 2. Chairman Zwanitzer.
Thank you, Mr. Chairman. With the adoption of the First Amendment, I don't believe I need to bring the second reading amendment number 2 at this time. So if no one's jumping up to argue with me, I would withdraw second reading amendment number 2.
Second reading amendment number 2 to House Bill 102 has been withdrawn. Senate File 102 having been read 2 separate times. The question is, shall the bill be read a third time? Hearing no objection is so ordered. The next Senate file for our consideration, Senate File 117. The reading clerk will read the bill.
Senate File 117, sponsored by Senator Pappas. Speech and hearing specialist licensing amendments, an act relating to professions and occupations.
Senate File 117 having been read 2 separate times. The question is, shall it be read a third? Hearing no objection is so ordered. The next bill for our consideration is Senate File 136. Reading clerk will read the bill.
Senate File 136, sponsored by Senator Perkins. Required Public Service Commission considerations, an act relating to public utilities.
There is an amendment. Chairman Zwanitzer.
Thank you, Mr. Speaker. I'm pleased to move second reading amendment number 1 to Senate File 136 and ask for your favorable consideration. And my apologies in advance. This is going to take a little bit of explanation time, Mr. Speaker, just so the body knows kind of what we're doing procedurally and where this comes from. And so I'm confident that many of you received emails on another Senate file called Senate File 16 dealing with net metering. That
Mr. Speaker Pro Tem, point of order.
Okay, that's your explanation of that. Okay, sorry, Representative Yen.
Mr. Speaker Pro Tem, the amendment isn't germane to the bill, and I'd like to get a ruling on that.
Sorry, Representative Yan, I did not hear or understand what you said. Sorry.
Mr. Speaker Pro Temp, the amendment is not germane to the bill, and I'd like to get a ruling on that.
Okay.
Yep.
Well, we'll go ahead and call the Rules Committee. They'll come forward. So we've had an objection to the relevancy to the bill or germaneness. Members, the Rules Committee has met and the chair is going to rule that the amendment is not germane outside the scope of the bill. Okay, there's a ruling of the chair. There being no further amendments, then Senate file.
Oh, Mr. Chairman.
Oh, I'm sorry. Chairman Zwanzer, thank you.
I would like to object if I could to your ruling.
Okay, so the ruling of the chair has been objected to, so it's up. This will be a roll call vote of the body. If I get this correct, it's my first time doing this. If you vote in favor of the objection, you're overruling the chair and finding that the amendment is in order and will continue the debate. Is that clear to all the members? Okay, Chief Clerk, call the roll. Excuse me. Go ahead.
Point of order, Mr. Chairman. I do believe that, and I don't know if the chairman is interested in this or not, but this is a debatable motion.
Of course it is. Does any member wish to speak to the objection? Chairman Swanson.
Thank you, Mr. Speaker, and I guess I'll start. I believe the charge of germaneness was whether or not the bill title was broad enough to incorporate the amendment I was bringing. The bill is about two major things, 136, reliability and cost externalities. And I would certainly submit to the body that net metering, for those of you, and I know it's a really complicated subject that I was going to explain, deals specifically with reliability and what the costs of power are in the grid and where those sources of energy come from and the cost externalities associated. I think agree that if this amendment that I brought was mandating the PSC to charge customers a different rate, but it does say may, and it talks about a public, a process and opportunity for hearing for them to, just like Senate File 136's title for consideration, to take this possibility as a consideration for cost externalities and reliability. So I believe that consideration language in the bill and in the amendment I'm bringing makes it germane. So that would be my argument to the body.
Yep. Representative Yan.
Thank you, Mr. Chair. So the title is for the Public Service Commission to consider reliability and cost externalities. It doesn't actually authorize the PSC to start charging people different rates. And so that's what the amendment essentially does, is it authorizes different utility rates for different people. And when we talk about consideration, I don't think consideration really does that when our statutes don't allow that currently, right? So this would change our statutes to authorize this ability to charge different rates, when right now the bill itself is only talking about consideration. So if this amendment was about studying for the PSC to study the cost externalities and reliability with net metering, I think that would make 100% sense. But right now the amendment as is talking about charging different rates, which is different than just consideration. Thank you, Mr. Speaker Pro Tem.
Representative McGuire.
Thank you, Mr. Speaker Pro Tem. So again, looking at the case law, the construction of the title or the catchphrase must be liberally and reasonably construed. And if you go in and read the case law, basically what the court wanted to make sure was that the fellow legislators weren't surprised by something new that came up in the statute or an amendment. When it comes to generality of the title, interestingly enough, and I love irony, interestingly enough, the controlling case is Public Service Commission case. And the court went on to say that the title of an act of the legislature may be sufficiently general and comprehensive to embrace every means and end necessary or convenient for the accomplishment of the general purpose expressed therein. And we're talking about externalities. I mean, that's pretty general. It also goes on to say that the title of a bill need not encompass all of the aspects of the statute which follows, and every person or thing therein affected need not be delineated. And again, that's because the court wanted to make sure that people weren't surprised as you're working with a bill. But I think that we all know that when you're dealing with PSC, you're dealing with rates and rate setting. So I would encourage you to vote in favor of the challenge to the chair. Thank you.
Mr. Majority Floor Leader.
Mr. Speaker Pro Tem, on and against the objection. And really it is quite simple to me. It's consider reliability as opposed to authorizing a charge. And it pulls in an entirely different piece of statute to do it. That's always a red flag for me. And so I oppose the objection, on and against the objection.
Any other members wish to speak to the objection for their first time? Any members for their second? Second time before the objector. Okay. Seeing none. Members, and I do apologize. I'm having difficulty hearing up here a little bit of that. So anyway, okay, so we are voting on the objection of the chair's ruling that the amendment was out of order. So that means that an aye vote would overrule the decision of the chair, in which case we would go ahead and hear the amendment and debate the amendment. So roll call, or excuse me, the chief clerk will call the roll.
Andrew. Baker. Banks. Bear. Blackburn. Blackburn. Brown. Burkhart. Burt. Clausen. Clifford. Connolly. Crago. Duncan. Eklund. Air. Flitner. Fortner.
No.
Gray. Greer.
No.
Hallinan. Haroldson. Aye. Harshman. Heiner. Henderson. Hunt. Jennings. Kenner. Knapp. Larson Lloyd. Larson Dan. McGuire. Martinez. Nyman. Newsom. Nicholas. Oakley. Obermuller. O'Hearn. Olson. Ottman. Paxton. Provenza. Roscoe. Schwartz. Sherwood. Simpson. Summers. Stith. Stivar. Sweeney. Walters. Washit. Western. Wharf. Williams. Wilson. Winter. Yin. Zwanitzer. Mr. Speaker. Blackburn. Closing vote. Are there any changes? Closing vote. The vote is closed. 28 aye, 32 no.
Members, by your vote, you have overruled the objection, sustained the ruling of the chair. Chairman Zwanzer.
Well, thank you, Mr. Chairman. I guess I'd like to withdraw amendment number 1 to Senate File 136. And my corporations committee might have another bill on the table tomorrow.
Thank you, Chairman Zwanzer. Senate File 136 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection is so ordered. The next bill for our consideration is Senate File 148. Reading clerk will read the bill.
Senate File 148, sponsored by Senator Rothus. Requirements relating to depositors amendments, an act relating to special purpose depository institutions.
Senate File 148 having been read 2 separate times, the question is, shall the bill be read a third? Hearing no objection is so ordered. So members, we're at that order of business of third reading consent. Mr. Majority Floor Leader. So I'll go to the script and do this correctly. We're at that order of business of bills on third reading and final passage. Mr. Majority Floor Leader.
Mr. Speaker Pro Tem, I move the consent list consisting of the following Senate files. Senate File 33, 74, 106, 107, 108, 109, 110, 116, 124, and 155.
Would anyone like to remove any of the bills from the consent list? Okay. Reading clerk will read, will the reading clerk read the bills on the consent list?
Senate File 33, sponsored by Senator Baldwin. Physician's Assistants Amendments, an act relating to physician's assistants being enacted by the legislature of the state of Wyoming. Senate File 74, sponsored by Senator Landon. Athletic trainer revisions, an act relating to athletic trainers being enacted by the legislature of the state of Wyoming. Senate File 106, sponsored by Senator Landon. Transportation Statutory Amendments 1, an act relating to highways and transportation being enacted by the legislature of the state of Wyoming. Senate File 107, sponsored by Senator Landon. Transportation Statutory Amendments 2, an act relating to highways and transportation being enacted by the legislature of the state of Wyoming. Senate File 108, sponsored by Senator Cooper. Career and Technical Education Terminology, an act relating to education being enacted by the legislature of the state of Wyoming. Senate File 109, sponsored by Senator Cooper. Board of Dental Examiners Amendments, an act relating to dentists and dental hygienists being enacted by the legislature of the state of Wyoming. Senate File 110, sponsored by Senator Nethercott. Small Claims Procedures, an act relating to small claims procedures being enacted by the legislature of the state of Wyoming. Senate File 116, sponsored by Senator Ellis. Wyoming Business Council Directors Reduction, an act relating to the administration of government being enacted by the legislature of the state of Wyoming. Senate File 124, sponsored by Senator Nethercott. Defending Wyoming Business Trade and Commerce Amendments, an act relating to trade and commerce being enacted by the legislature of the state of Wyoming. Senate File 155, sponsored by Senator Driscoll. Limiting firearm seizure and regulation during emergencies, an act relating to homeland security being enacted by the legislature of the state of Wyoming.
Having been read 3 separate times, the question is, shall these bills pass the House? The chief clerk will call the roll.
Roll call on the consent list. Andrew. Baker. Banks. Bear. Blackburn. Brown. Burkhart. Burt. Clausen. Clifford. Connolly. Crago. Duncan. Eklund. Air. Flitner. Fortner.
Aye.
Gray. Greer.
Aye.
Hallinan. Haroldson. Harshman. Heiner. Henderson. Hunt. Jennings. Kenner. Knapp. Larson Lloyd. Larson Dan. McGuire. Martinez. Nyman. Newsom. Nicholas. Oakley. Obermuller. O'Hearn. Olson. Ottman. Paxton. Provenza. Roscoe. Schwartz. Sherwood. Simpson. Summers. Stith. Stivar. Sweeney. Walters. Washit. Western. Orf. Williams. Wilson. Winter. Yin. Zawanitzer. Mr. Speaker, we have 60 aye. As for Senate File 33, are there any changes? Larson Dan, aye to no. Hallinan, aye to no. Winter, aye to no. Knapp, aye to no. Bear, aye to no. Gray, aye to no. Heiner, aye to no. Haroldson, aye to no. Stivar, aye to no. Jennings, aye to no. Western, aye to no. Worf, aye to no. Further changes? Closing. Haroldson, no to aye. Correct?
Did you, Chief Clerk, you got Representative Fortner? Representative Fortner?
Representative Fortner, aye to no. Stiff? Aye to no. Further changes? Olson, aye to no. Further changes? Closing vote. The vote is closed. 46 aye, 14 no.
As for Senate File 74, are there any changes? Larson Dan, aye to no. Larson Lloyd, aye to no. Further changes?
Representative Fortner, Chief Clerk.
Fortner, aye to no. Further changes? Closing vote. The vote is closed. 57 aye, 3 no. As for Senate File 106, are there any changes? Gray, aye to no. Simpson, aye to no. Further changes? Winter, aye to no. Further changes? Closing vote. The vote is closed. 57 aye, 3 no. As for Senate File 107, are there any changes? Are there any changes? Winter, aye to no. Further changes? Closing vote. The vote is closed. 59 aye, 1 no. As for Senate File 108, are there any changes? Are there any changes? Closing vote. The vote is closed. 60 aye. As for Senate File 109, are there any changes? Bear, aye to no. Further changes? Closing vote. Vote is closed. 59 aye, 1 no. As for Senate File 110, are there any changes? Are there any changes? Closing vote. The vote is closed. 60 aye. As for Senate File 116, are there any changes? Schwartz, aye to no. Further changes?
You have Representative Fortner, Chief Clerk.
Fortner, aye to no. Further changes? Closing vote. Vote is closed. 58 aye, 2 no. As for Senate File 124, are there any changes? Are there Burt, aye to no. Further changes? Closing vote. Vote is closed. 59 aye, 1 no. And as for Senate File 155, are there any changes? Are there any changes? Yin? Aye to no. Schwartz? Aye to no. Connolly? Aye to no. Clifford? Aye to no. Further changes? Closing vote. The vote is closed. 57 aye, 3 no.
Having received the affirmative vote of the majority of the members elected to the House, Senate Files 33, 74, 106, 107, 108, 109, 110, 116, 124, and 155 have passed the House. Chairman Olson.
Yeah, thank you, Mr. Speaker Pro Tem. Pursuant to House Rule 7-3, I move to lay back Senate File 96 for 1 day.
Hearing no objection, Senate File 96 will be laid back 1 day. We are at that order of business bills on third and final, or on, excuse me, we're at that order of business of bills on third and final passage. The first bill for our consideration is Senate File 87. There are amendments.
Senate File 87, sponsored by Senator Cost. Voyeurism amendments, an act relating to crimes and offenses being enacted by the legislature of the state of Wyoming.
Okay, for the First Amendment, again, there are amendments, and the First Amendment is Chairman Olson.
Thank you, Mr. Speaker Pro Tem. So a little late getting this one to you all. This is the amendment that adjusts the standard felony. We actually voted on this and adjusted this in our committee. It was intended to be in the standing committee amendment that you voted on in your initial reading. And, sometimes that happens. It just didn't make it in there. So here it is. And, the real reason for this adjustment is parity. So in the bill, the Judiciary Committee adjusted the penalty if you commit this a felony act of voyeurism against a minor. So originally the bill was a little confusing in that it had a mandatory minimum and a maximum, and we really don't do that in Wyoming law. So we deleted that mandatory minimum maximum kind of scenario, and we just set a maximum. But your House Judiciary Committee, the maximum in the original bill was 5 years for an act against a minor. Your House Judiciary Committee considered that if you commit the act of voyeurism, if you're an adult and you commit an act of voyeurism against a minor, we consider that pretty heinous. So we made that a 10-year, up to 10-year felony. So the reason for this is parity. It doesn't make sense to have a 10-year penalty for an act against the minor, but if you commit the exact same felonious act against an adult and you are an adult, to only have 2 years. And I spoke a little bit about this in the standing committee amendment. A lot of this deals with the time that we want an individual to serve. If we say a felony is up for 2 years and someone is sentenced for that felony 2-year sentence, there is very unlikely that they will serve 2 years. They're going to get good time and likely only serve a year and then be out on parole. So in adjusting this up to 5 years, it brings parity, makes more sense with the minor provision. And what we're really saying is we think someone's probably going to serve 2.5 years in prison. And so that's what the amendment does. Just a little bit stricter on this so the legislature can show that it's serious about the crime of voyeurism.
Any other members for the first time? Any members for the first time? Okay, second time before the sponsor. Okay, we are voting on third reading amendment number 1 to Senate File 87. All those in favor say aye. Those opposed? The amendment is enthusiastically adopted. We're now on to the second amendment. Madam Minority Floor Leader.
Thank you, Mr. Speaker Pro Tem. I move third reading amendment number 2 to Senate File 87, and I ask for your favorable consideration. Friends, first let me apologize that I wasn't on the floor last week, or I would have brought up this issue at that point. I can't look at the voyeurism statute without thinking about 605, the next statute. And I'm going to start using the colloquial names for these statutes and what we're doing here. So 605 is a statute that we passed 4 years ago that addresses sexting. Right? It's got a big other fancy title, but it addresses sexting. 4 years ago, we as a body decided that we needed to address the reality that kids were engaged in this activity. Let me assure you, me and no one else in this body are in favor of sexting. But what was going on, or the way that our statutes were written, when kids were engaged in this activity, you either went to the voyeurism statute that we're dealing with right now, or our child porn statutes. Because if they are doing that activity, they end up with nude images of children, right? Child porn, right? Or voyeurism, again, a felony. What we decided is that we needed to address the activity by children differently, right? That was important. We did not want 16-year-olds and 17-year-olds with felonies for very bad behavior, right? But behavior that we see as an adult as deserving of a felony status. So 605, if you look at your green books, all right, outlines sexting, outlines punishment that goes with sexting, right, for children. In 604 now, and this is a bill that addresses revenge porn, right? So it's voyeurism, but it really addresses revenge porn, right? Can kids be involved in this activity as well? Sure they can. But what this amendment does is acknowledge when a child is involved in what we see with voyeurism, we do not want that kid to be charged with a felony. We just don't. It destroys individuals' lives, let's face it. We want them punished, right? There's no two ways about it. So what this amendment does is goes into the two sections of the kind of amended voyeurism statute and says, if you are doing this behavior when you're a child, right, there is not a felony, but a status offense. Same as the language that we used in 605 for sexting. And so with that, I would encourage your favorable consideration.
Chairman Olson.
Yeah, thank you, Mr. Chairman. Super friendly amendment. If you recall the exchange between, which you probably don't because we've had a lot of bills and a lot of exchanges, but if you recall the exchange between myself on presenting the bill and the Good Country lawyer, this issue was pointed out. You know, we actually attempted to address this in the Judiciary Committee and we deleted almost all of page 4 and the top of page 5. And we thought we hit it, but we obviously didn't quite get it. So, you know, your Judiciary Committee considered this policy, wants it to be consistent. The idea is not to make felonies or felons, excuse me, out of minors making dumb choices. So I think this is a really good amendment.
Representative Washington.
Thank you, Mr. Chairman. I'm not sure it's a really good amendment. You know, when we think about people under the age of 18, that's quite a range. We start talking about 12 and 13-year-olds doing this type of conduct. A little different story than when they're a day away from their 18th birthday. So it is a policy call for the body, but I would suggest that this is a serious form of misconduct, and we might want to think twice about whether or not this should just be a status offense akin to having a beer when you're under 21 or having tobacco when you're under age. So status offense, you know, if the violation of the voyeurism involves my family members, how would I feel about that?
Speaker Pro Tem Greer.
Thank you, Mr. Chairman. So I encourage an aye vote on the amendment, co-sponsor on this amendment. And again, maybe it's my soft heart, but I look at, you know, we've done a lot of work on expungement. We do a lot of work dealing with our youth, and today's world's different than it was 30 years ago, where the judge would give you the option to go off to the military. You can't even get in the military anymore if your record isn't clean. It's difficult. These things will carry with you for a long time. This ties in with the work that we did several years ago regarding the sexting and trying to deal with this situation. So we have young people here who have, in this day and age, have different views, different technology than what we grew up with. It's a different world. And, you know, so we're looking at natural curiosity, horseplay, blatant stupidity. And I just always have a concern with tagging young people with a felony in that situation. You know, if they are tagged with a status offense and it were to come back again, they're there in front of the judge and there's proceedings to deal with that. You know, they do it 2 or 3 times. Maybe they're in, you know, dorm 3 out at the boys' school in my community. But this really want us to think, and as was said by the prior representative, it is a policy decision. It's a policy decision where I feel to be understanding with young people. We're not letting them walk free, but to tag them with a felony seems a bit much. And so I'd ask for an aye vote. Thank you.
Thank you, Mr. Speaker Pro Tem. Anyone else for the Chairwoman Flitner?
Thank you, Mr. Chairman. I'm on and for the amendment. I would rather err on the side of caution when we're dealing with someone underage. I feel like if they have a problem, it'll probably rear its ugly head again, but in terms of under the status of being adult, I think we better err on the side of caution. On and for the amendment.
Thank you, Chairwoman Flutner. Anyone else for their first time? Any other members for their first time, for their second time? Any members for their second time? Minority Floor Leader Conley.
Thank you, Mr. Chairman. I'll just call for the question.
And an opportunity for the bringer of the amendment. Oh, I'm sorry. Thank you, Minority Floor Leader. All right, question having been called. All those in favor, please say aye. Any opposed, say no. The amendment has been adopted.
Thank you. We do have one more amendment. Chairman Nicholas.
Thank you, Mr. Chairman. I move third reading amendment number 3 to Senate File 87 and ask for your favorable consideration, ladies and gentlemen. So what this does, ladies and gentlemen, it takes the penalty that as it came from the Senate and it takes it back to the 2-year penalty for this offense. So why is that? Well, here's a couple different. First of all, I just want to talk about what it's important, I think, that when you have penalties in the statute, that you make them commensurate with other crimes so that there's kind of a rationality to it. So I just went through the statutes yesterday and looked at other crimes that may be worse than voyeurism. There's homicide by vehicle, that's a 1 year. Criminal negligent homicide, that's a 1-year maximum penalty. False imprisonment of a person, that's a 1-year penalty. Sexual battery, that's a 1-year penalty. Sexual servitude of an adult, that's a 3-year penalty. So those are the type of penalties that already exist or are out there. And so as I compare it to this, I'm going, well, how do you balance the process? And let's talk a little bit about what voyeurism is. So if you're doing setting up a camera or some other event in a clandestine, surreptitious, prying, or secretive nature, the chances are almost perfect that you're violating other laws besides this particular law. So you're either trespassing or you're doing something on private property as a trespass or in a public place. But you're doing something which means you won't be prosecuted just for one crime. You'll be prosecuted for 2 or perhaps 3. Now, so let's say you put in a camera. So let's just say, and let's assume that camera was discovered 5 days, or it's been there 5 days, and you had 15 different people in that restaurant. Each one of those is a crime. And so that means that you could charge that person for a 5-year, maximum 5-year penalty. And the total number of sentences would be over 150 years at 5 years, because each one of them individually is a crime against a different person. And so you've got different elements of it for each one of those persons. I'm just suggesting that, I mean, it's a heinous thing to do, but is it worse than homicide? I don't think so. And, you know, the crime stacks on top of each other. There are other crimes committed at the same time. So if you want to get someone for this, trust me, he's going to spend a lot of time in jail, depending on the severity of the act. And that's the other thing that's interesting about voyeurism is there's a broad spectrum of the type of act that's involved and the sophistication of it, which I think lends itself to having the ability to actually not give 2 years to everyone that ever committed this crime. So in favor of the amendment and for the bill.
Any members for the first time? Any members for the first time? Chairman Olson.
Yeah, thank you, Mr. Chairman. On and against the amendment, I want to address a few things. Number one, parity in existing law is the concern. The testimony we heard from a woman who was a victim of voyeurism, one of her number one concerns was that the penalty wasn't strict enough. And in her particular instance, the footage wasn't just of one individual. There were, after discovery, hundreds of individuals were victimized. That's the problem with voyeurism. There is a broad spectrum. Sure, you might get a one-time offender, but the testimony that we heard, they're individuals with literally hard drives of videos. And you're not able to go after the hard drive of individuals because you have to go and identify all the victims, et cetera. So how do you weigh that when you have a one-time offender and a person who filmed hundreds of women and got caught one time? Well, it's in the magical language, up to. That's why we don't have mandatory minimums in Wyoming. If you reject this amendment and leave it how the bill is now, it says not more than, or in other words, up to 5 years. The judge has discretion. If it's a one-time offender and the judge thinks this person falls on that end of the spectrum, the judge can sentence the individual to 1 year. But if there's substantial evidence of a repeat offense or hundreds of videos, which is common, can sentence up to 5 years. So you leave that discretion with the judge. It's 5 years and 10 years if you commit this act against a minor is not a minimum. It's really a maximum. You can sentence up to that amount. The other thing that, parity in law is important with offenses. Recording a conversation without your consent will get you 5 years in prison. But somebody recording your wife or your spouse will get you 2 years in prison without their consent. That doesn't make any sense. Why would we sentence someone for recording the phone call to 5 years, but recording intimate images of a woman to only 2 years? So that's why we've ratcheted it up. I think the discretion that we leave with the judge is just enough to ratchet the sentence down when it mandates it, but be tough on it when it needs to be. And I'll just say this, folks, and I think this is really important. The reason why this bill, at least from my perspective, is so important is because it treats voyeurism as the sex crime that it is. And that's why we're getting serious with the penalties. So if there's some other issues with other sex crimes in sentencing, let's take those up and let's adjust those sentences. As the good chairman of appropriations pointed out, maybe those sentences are too low, but that's not a reason to not be tough on this crime in this instance. So on and against the amendment for the bill. This has been a long time. I've seen this for 2 years now, trying to work through these voyeurism statutes, and we're this close to having a bill. I think we need to get it over the finish line.
Representative Oakley.
Thank you, Mr. Chair. So I guess I think it's basically been said. So I'm just going to reiterate. Reiterate what the good chairman just said. But more importantly, I wanted to talk to some of the stuff that the defense attorney said. I can definitely tell when you get defense attorney. So, saying that homicide, is a 1 year. The only thing that includes homicide, perhaps we should look at this, but when you're talking about criminally negligent homicide, it's an accident. That's what it is. An accident occurred and it resulted in the death. The reality is homicide, our homicides are 20 to life, or first degree is life in prison. Extremely high penalties. I think there was a little bit of a, this certainly isn't an accident, and that's what he compared it to. The reality is this type of punishment is exactly in line with probably the largest bulk of what the punishment is for felonies. Burglary is a 10-year, theft is a 10-year, or if it's a felony level, which is over $1,000. Does that mean that they go to prison automatically, or that we put them in prison for 10 years? Usually not. But that is what you'd have in felony sentencings, is that range, so that there is an ability to look at the look at the case. We do, every case is a case by case basis and analyze what's appropriate. And that's when I'll piggyback off the last good speaker saying, I mean, maybe there are crimes where this is very significant. This gives us the opportunity to take that case into account and give the appropriate punishment. So, as we discussed this, we talked about penalty and punishment, and we listened to the victim testimony, and this is where we came to. I think it's appropriate to give the court the opportunity to analyze it case by case and leave it as it is. So I'm speaking on against the amendment and for the bill.
Any other members for the first time? Members for the first time? Any members for the second time? Second time before the sponsor? Chairman Nicholas?
So, ladies and gentlemen, what's interesting is I didn't really hear a cogent argument against the reason I brought this amendment. And that is compared to other crimes, vehicular homicide, criminal negligence, both 1 year, false imprisonment of a human being, 1 year, sexual battery, 1 year, stalking, 1 year, sexual servitude of an adult, 3 years. And yet every type of voyeurism, if you're over 18 years old, is a 5-year penalty. And there was no discussion about the repetitive nature of voyeurism, so that you would have multiple counts anytime you catch somebody, which means that they could be subject to 5, 10, 20, 30, 40 years in prison by installing one camera, literally. And how do you compare that? That's manslaughter is 20 years. So I just think that we need to step back and say, are we going to fill our prisons? I mean, the argument was, let's raise the penalty of everything else too. We're got overcrowding our prisons right now. So I just don't think that that's the solution. So on in favor of the amendment.
Members, we are voting on third reading amendment number 3 to Senate File 87. All those in favor say aye. Opposed? The amendment's been adopted. Division being called. All those in favor of the amendment, please rise. Chief Clerk, I'm an aye. I'm an aye on it. All those opposed, please rise. Less than 36, the amendment has been adopted. Senate File 87 having been read 3 separate times, the question is, shall the bill pass? The Chief Clerk will call the roll.
Andrew, Baker, Banks, Bear, Blackburn, Brown, Burkhart, Burt, Clausen, Clifford, Connolly, Crago, Duncan, Eklund, Air, Flitner, Ortner.
Yes.
Aye.
Representative.
Aye.
Gray. Greer.
Aye.
Hallinan, Haroldson, Harshman, Heiner, Henderson, Hunt, Jennings, Kenner, Knapp, Larson Lloyd, Larson Dan, McGuire, Martinez, Nyman, Newsom, Nicholas, Oakley, Obermuller, O'Hearn, Olson, Ottman, Paxton, Provenza, Roscoe, Schwartz, Sherwood, Simpson, Summers, Stith, Stibar, Sweeney, Walters, Washit, Western, Wharf, Williams, Wilson, Winter, Yin, Zawanitzer. Mr. Speaker, Closing vote, are there any changes? Western, I to no. Zawannitzer, no to I. Jennings? Further changes? Closing vote. The vote is closed. 57 I, 3 no.
Senate File 87, having received the affirmative vote of the majority of the members elected to the House, Senate File 87 has passed the House. The next bill for our consideration is Senate File 115. The reading clerk will read the bill.
Senate File 115, sponsored by Senator Cost. Education, public teacher contact time, an act relating to education. Being enacted by the legislature of the state of Wyoming.
There is an amendment. Mr. Majority Floor Leader.
Mr. Speaker Pro Tem, thank you. I'd like to move third reading amendment number 1 to Senate File 115 and ask for your favorable support and consideration. And so basically, the good department that deals in education had some technical amendments to this that were brought to me by the prime sponsor of this bill. And really, that's it. It just brings in that back into that word contact, and then the deletion is kind of, it doesn't matter at that point because it says contact time. So on and support, and I'd certainly answer any questions.
Any other members for the first time? Any members for the first time? Members second time before the sponsor? Okay. We are voting on third reading amendment number 1 to Senate File 115. All those in favor say aye. Opposed? The amendment is adopted. Senate File 115 having been read 3 separate times. The question is, shall the bill pass? Chief Clerk will call the roll.
Andrew, Baker, Banks, Bear, Blackburn, Brown, Burkhart, Burt, Clausen, Clifford, Connolly, Crago, Duncan, Eklund, Air, Flitner, Fortner,
No.
Gray, Greer,
Aye.
Hallinan, Haroldson, Harshman, Heiner, Henderson, Hunt, Jennings, Kenner, Knapp, Larson Lloyd, Larson Dan, McGuire, Martinez, Nyman, Newsom, Nicholas, Oakley, Obermuller, O'Hearn, Olson, Ottman, Paxton, Provenza, Roscoe, Schwartz, Sherwood, Simpson, Summers, Stith, Stibar, Sweeney, Walters, Washit, Western, Wharf, Williams, Wilson, Winter, Yin, Zawannitzer. Mr. Speaker. Closing vote. Are there any changes? Olson? No. Further changes? Closing vote. The vote is closed. 53 aye, 7 no.
Okay, Senate File 115, having received the affirmative vote of the majority of the members elected to the House, Senate File 115 has passed the House. Representative Jennings.
Privilege, Mr.
Go
Speaker.
go ahead, Representative Jennings.
In your south gallery is my baby daughter. Down here yesterday, my oldest daughter, but today all the way from Sheridan, Kristen Jennings.
Welcome to the House. Representative Eklund.
Mr. Speaker Pro Tem, privilege.
Go ahead, Mr. Chairman.
So normally things are a little different than they have been, and we see a lot more of our families up here. A lot of you don't know my wife. She's sitting in the North Gallery. Susie, I'm just going to have to embarrass you. She's my life support system in this legislature.
Representative Haroldson.
Thank you, Mr. Chairman. Privilege of the floor.
Proceed.
I have the privilege of having my son with me today, as some of you guys have seen, but he's sitting over here. Malachi, if you want to stand up. And Malachi is joining us today, so thank you, guys.
You know, for those three representatives, it's very, very good to have their family down here keeping an eye on them. So we very much appreciate that. So okay, Chairman Nicholas,
Privilege of the floor, please.
go ahead, Mr. Chairman.
So, ladies and gentlemen, most of you know, but some of you may not have attended, but every year we do a little crab party for all the legislators, House and Senate, and it's a good time. And because of the odds, because Tuesday and Wednesday may be virtual for lots of us, the crab is going to be Thursday night on adjournment or close to 5 or 6 o'clock. But you're all welcome. You're welcome to bring your kids, your family, but come and enjoy all the crab you can eat. So can't wait to see you.
Mr. Majority Floor Leader.
Mr. Speaker Pro Tem, I move the House stand in recess until 1:45. 1:45.
You've heard the motion. All those in favor say aye. The House will stand in recess. Go ahead, Representative Burkhart, before I.
Thank you, Mr. Speaker Pro Tem. Committee announcements?
Yes, committee announcements. I'm kind of a rook on some of this still, so committee announcements.
Thank you, Mr. Speaker Pro Tem. Committee number 8, Transportation, will meet, let's say 10 minutes in East 3 in the tunnel. Thank you. To consider one bill, Senate File 73.
Any other committee announcements? Okay, Representative Simpson.
Mr. Speaker Pro Tem, the Joint Conference Committee on House Bill 49 will meet today at 1 p.m. in room W113.
Representative Larson.
Thank you, Mr. Chairman. Your Select Committee on Tribal Relations will meet tomorrow at noon to discuss interim topics in the tunnel in room 6. Thank you.
Chairman Flintner.
Mr. Speaker Pro Tem, Committee number 6 will be meeting at 12:30 with our Senate colleagues to discuss interim topics. And I don't know which room we're in, but I'll figure that out. Thanks.
Any other announcements? Okay, we will